Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a new piece of federal legislation, Bill C-9, the Combating Hate Act. I had the privilege of appearing at parliamentary committee on this proposed new law, where I outlined some of my concerns. The law would result in more investigations, charges, prosecutions, and convictions for speech, including online speech, that the government deems hateful. Now, I want to be very clear. Hate is wrong and it causes real harm in society. Hateful conduct, especially violence and threats, must be confronted. But criminal law is our most powerful state tool, and it carries the highest stigma and most serious consequences for liberty. It must be used with restraint, especially in matters touching expression, belief, and political and religious discourse. I believe that Bill C-9 expands the criminal law into the realm of expression in ways that risk unjustified violations of the Charter right to free expression. It lowers existing constitutional thresholds, removes safeguards against politicized or abusive prosecutions, introduces vague new offenses, and risks chilling lawful debate and protests. That's what I said at committee. Now, here today are two experts who also presented at committee on this bill. Derek Ross from the Christian Legal Fellowship, and Anais Boussière-McNichol from the Canadian Civil Liberties Association. Thank you both so much for joining me today. Now, I think we all share the same concerns about the rise of hate in Canada, but I'm very concerned about that issue, but I also want to ensure that what we do to address hate is constitutional and that it actually works. And right now, Canada does have prohibitions against hate propaganda offenses in Section 319 of the Criminal Code. And Anais, maybe you could tell me about what the law already says right now before C9 enters the picture.
Absolutely. So the criminal code prohibits public incitement of hatred, which means publicly inciting hatred against an identifiable group in a way that is likely to lead to a breach of the peace. The criminal code also prohibits willful promotion of hatred, which means making a statement other than in a private conversation, in which one promotes hatred against an identifiable group. The notion of hatred has been defined by the Supreme Court of Canada as an emotion of an intense and extreme nature that is clearly associated with vilification and detestation. So what that means, and the Supreme Court of Canada was clear to that effect, is that expression that merely offends, hurts, or humiliates is not hate speech. So the bar is quite high.
Yeah, and I think one of the concerns that I have, and I think both of you share, is that C9 might be lowering the threshold for what constitutes hate. We have that definition of hatred that you just gave, Anais, that comes from the case law, specifically from the cases of Keegstra and Whatcott. But what Bill C9 does is it proposes a new definition. Derek, maybe you could tell me a little bit about what's being proposed and why it might actually be lowering the threshold for what constitutes hate.
For sure, Christine. And just want to reiterate your point. When we express concerns with a law like Bill C-9, it's not because we disagree with its intent. It's precisely the opposite. It's because the combat of hatred is so important that we want to ensure that these efforts are both effective and constitutionally sound. And that is a concern with this new definition of hatred that is being introduced into the bill, is it's missing some of that language that my colleague just mentioned. It doesn't make reference to extreme manifestations. It doesn't use the word of intensity. It refers to the emotion of vilification and detestation. And without some of those added prescriptions from the Supreme Court, such as extreme manifestation and intensity, um, without that language and other prescriptions, the concern is that the focus now may be lower, that the focus is more on the emotion, perhaps the accused's emotional state of mind. The focus on emotion also raises concerns about subjective interpretations, focusing more on the feelings of the accused or the feelings of a complainant, and particularly not focusing on the effects of the expression, which the court has said we must focus on. What are the effects of the expression, not necessarily its content?
Yeah, I mean, the idea of willful promotion of hatred includes an element of causing another person to have this feeling. It's not just about your own internal subjective mental state. It's the intent requirement, the mens rea requirement to cause this in other people. this seems to become a little more blurred with this definition, as well as just removing some of that qualifying language. We've got to go to break right now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the new federal bill C-9, the Combating Hate Act, and some concerns that civil libertarians, myself included, have about this proposed bill. Now, one of the things that Bill C-9 does is it removes the requirement that the Attorney General consent to charges of hate propaganda. So, right now, if there's going to be if someone is suspected of committing one of these hate propaganda offenses, in order for the police to bring the charge, they first need to obtain consent from one of the provincial attorneys general. Anais, maybe you could explain why that's required now and what the risks are of removing that requirement.
Absolutely. We see this as a very dangerous amendment because, from our perspective, there's simply no benefit to the police filing hate propaganda charges that the Attorney General would not have proceeded with in the first place. To the risk of stating the obvious, hate propaganda charges criminalize expression. This directly engage the charter protected right that is freedom of expression and conscience. There's also this very complex notion of hate speech, which is not only legally complex, but also a subjective notion. So when you put all of that together, respectfully, the analysis of those notions is not within the police's expertise. So the Attorney General consent requirement is a key institutional check that promotes a legally informed and proportionate public interest assessment before criminal prosecutions proceed.
Derek, what's your thought on this Attorney General consent requirement? What role it serves now, and what could happen if that requirement's removed, as is suggested in C-9?
Well, again, it goes back to a core concern about criminalizing expression in the first place, which is how do we ensure that it is properly used as a tool to combat hatred and does not itself become a weapon of hatred to suppress speech that is not at all hateful, but actually hated by people that find it offensive. And it is usually those who are in the minority, those who hold minority viewpoints, that are most at risk of having their speech viewed as quote unquote hateful. And so it's ironic that the law, which is designed to protect minorities, might actually be more susceptible to misuse against minorities without a safeguard like this, which ensures that someone who is impartial, objective, publicly accountable is there to ensure that there aren't politicized pressures placed on some of these minority groups to try to silence their controversial expression.
Yeah, very well put. Now, one of the other provisions of this bill that I think is probably politically popular, but that I myself have some concerns with, is this provision to criminalize the use of what are called hate symbols when they are used to promote hatred. The bill specifically lists certain symbols, including the Nazi hooked cross, sometimes called the swastika, the SS bolts, and then it also would criminalize the use of insignia of various terrorist groups when they are used to promote hatred. And those symbols are incorporated into C-9 by way of reference to regulation that is controlled by cabinet. Now, these symbols are obviously vile symbols that I condemn the use of these symbols for hateful purposes, but I do have some concerns about making the use of these symbols on its own a criminal offense. And I think that the way you could read this bill might be interpreted to mean that just the display of one of these symbols is a criminal offense. Anais, what do you think of the symbols provision? Could you read it that way, that now just flying a swastika would be a criminal offense on its own? And what do you think the dangers might be of just outlawing those symbols, as appalling as they are?
So I agree with you that there's certainly a tension between the actual text of the provision and how the Justice Minister publicly presented it. The Justice Minister insisted that this new provision is not a blanket ban on the public display of listed symbols. But that's not so clear from the text, and there's certainly room for clarification here.
Yes,
And what's
I mean, a court
peculiar,
interprets the text. They don't interpret
right?
what the minister says at a committee meeting. That might inform the court, but the text is what it says. Parliament only votes on the text.
And what's really peculiar is that if we accept the justice minister's interpretation of this new provision, well, that means that the new provision is simply redundant because under the current criminal code, the public display of a hateful symbol can already be part of a broader pattern of behavior that leads to a criminal conviction.
Yeah, I mean, I just do not think that we are safer by not knowing what opinions people hold. I think we're better off knowing people in our neighborhood hold these vile views so that we can either confront them with the truth, with better views, or we can stay away from them. I don't think the criminal law is the right avenue for this. We've got to go to a commercial break, but we'll be right back. Welcome back to Canadian Justice, where we are discussing the new federal government's planned piece of legislation, the Combating Hate Act, which would increase the criminal penalties for various hate crime related offenses. One thing that it also does is it creates a new offense of a standalone hate crime. Anais, can you explain what exactly is being proposed and what maybe some of the risks are with this standalone hate crime proposal are?
C-9 creates a new offense whereby anyone who commits any federal offense, if motivated by hatred against an identifiable group, would face a maximum sentence that would be significantly harsher than it would have been otherwise. So the provision is a significant departure from the current treatment of hatred in criminal law, because right now, the fact that an offense was motivated by hatred is an aggravating factor at a sentencing stage. So once the accused has been found guilty of an offense. And the CCLE sees a lot of risks to this proposed shift because instead of leaving the assessment of hatred to the sentencing judge, C-9 places it in the hands of the police at the very beginning of the judicial process. And we think that outside some obvious cases, the police officers will not be in a position to identify whether someone was allegedly motivated by hatred against an identifiable group or rather by anger or personal resentment. So this definitely stems the question of what will the police do in case of doubt? Will they include the hate crime charge just to err on the side of caution?
Yeah, and a concern that I actually have is the risk of overcharging in order to create pressure on an accused person to plead out. Because if now you have this potential additional charge that it was an offense motivated by hatred with massive potential penalties, the Crown could charge both. And the accused, who might have committed a otherwise minor offense, might simply choose to plead guilty in order to avoid those higher sentences. Now, obviously, crowns are not supposed to overcharge, but anyone who's worked in the criminal justice system knows that this is something that does happen and that there is always pressure to enter into a plea. And I think that this increases the risk of that happening in a really, in my view, intolerable way that risks the constitutionality of this bill. Another thing, Derek, that this bill does is it proposes a new prohibition on obstruction and intimidation around places of worship and cultural spaces. Now, my understanding is that obstruction, intimidation, these are already offenses under the criminal code. Harassment, blockades, those are already offenses. Maybe you can tell me what the government's proposing here and if it's actually going to achieve anything different. I mean, I think we all have seen protests that we find unacceptable, but is this the right approach to what the government's proposed doing here?
Well, that's the debate, isn't it? And I think where the government is coming from is recognizing that unfortunately there is an increase in the types of intimidations and obstructions. And police reports are telling us that there is an increase in hate motivated incidents. So I understand the intent of where this is coming from. But as you say, Christine, there are already provisions that exist in the criminal code to deal with intimidation, to deal with vandalism and destruction of property. So the question is this adding something or is this adding more confusion? And I think there is a concern about things like how do we interpret what constitutes interference? Does being forced to take a different route or being inconvenienced by the presence of a crowd, does that constitute with interference? So there's some real questions about how this might impact legitimate, constitutionally protected assemblies and protests that are part of what it means to be in a free and democratic society. It's going to be messy sometimes. The question is, where do we find that balance while also ensuring that we address the very real concern um, of protecting members of society from hate inciting conduct? Our view is that there are existing provisions already in the criminal code that could be better utilized, perhaps through further training to address some of those concerns.
And I guess, what's your view? And one of the things I think that needs clarifying is this different from the bubble zone laws that we're seeing in some municipalities?
There are definitely some differences. For one, bylaws are not criminal laws, so people will not go to jail if they violate them. They will receive fines. But there are also similarities, as Derek mentioned. Both frameworks risk targeting protest and speech that are non-violent and non-threatening, on the ground that some see them as offensive or disruptive. So in both cases, we're talking about a risk of chilling and suppressing protected expression and peaceful assemblies.
Hmm. We've got to go to commercial break, but we will be right back to continue this conversation. Welcome back to Canadian Justice, where we're discussing Bill C-9, the Federal Combating Hate Act, that I testified at committee about at the House of Commons, and so did my guests here today. One question that everyone was asked at committee was from the Bloc Québécois member. It was about Section 319, sub 3 of the Criminal Code, which includes a defense that no person shall be convicted of the willful promotion of hatred if the statements were true or if they were a good faith expression of an opinion on a religious subject or based on a religious text. Now, the Bloc Québécois has suggested removing this defense. Derek, I know you have strong opinions on this. You had a big back and forth with the Bloc member and with the chair of the committee, actually, about this. What is your take? Should that defense be removed? And what, if not, why not?
Well, first, let me say I understand why there might be some unease about any defense to hate speech. There's a view of why would we allow something that might otherwise be considered hateful to exist? And my response to that is the defense is actually saying that this is not otherwise hateful, that this is actually providing a signal as to where we can appropriately and constitutionally draw a line between controversial expression, perhaps, and hate inciting conduct, which is appropriately targeted by the law. And so what this defense does is it guards against that chilling effect that we talked about earlier, because there is always, especially in the religious context, going to be strong views, both for and against a particular religious truth claim. But when we talk about protecting people from fear, we also have to talk about the legitimate fear that minorities especially might have about not being able to speak up and share their views, their beliefs, their concerns without fear of themselves being criminalized or being shamed into silence or having hatred or violence incited against them because of their beliefs. And that's what this religious opinion defense and the other good faith defenses protect, is ensuring that the law doesn't intrude too far on the ability of citizens to engage fully and equally in public discourse. And in fact, the Supreme Court has viewed these defenses as an important consideration in upholding the entire constitutionality of the anti-hatred regime.
And I think it's worth noting that, as far as I know, these defenses have actually never been successfully used. One of the parts of the defense requires it to be a good faith religious statement. Maybe, Derek, you could explain a little bit more about what that term actually means. I mean, good faith is something we see in law a lot. What does it mean in this context?
For sure. And the good faith component has done a lot of heavy lifting in the court cases that have interpreted this defense. And the courts have interpreted as precluding scenarios where individuals are just applying a thin, disingenuous religious veneer over hateful expression. What good faith does is it says bad faith expression is excluded. Calls to violence, for example, have been specifically excluded from the scope of this defense. So, what does good faith encompass? It encompasses a good faith, a reasonable, a well-intentioned effort to try to reason with others to discern matters of transcendent or religious truth, of engaging in dialogue and trying to figure out the truth of the universe. So, as you mentioned, Christine, there's already a defense for truth, but how do you prove a religious claim? The courts cannot be arbiters of religious dogma. So, what this does is preserve a certain degree of epistemic humility to say that when it comes to religious truth claims about the existence of God or whether he has a design for how we should live our lives, that we have to allow individuals to seek truth about these things without fear of being labeled hate mongers simply because others might view their religious beliefs as offensive. And let's face it, when it comes to religion, we're talking about universal truth claims, moral truth claims. People are going to be offended by them if they don't share them because one person's universal truth claim is by definition a rejection of all other competing truth claims. And so it's understandable that this causes disagreement, but that disagreement is not tantamount to detestation. And that's what's so important about these defenses is they ensure that ideas can be debated without saying that debating ideas is itself a hateful act. And we
Yeah,
think that's a really important thing to preserve.
really interesting. And I'm glad you got that argument out there without being interrupted this time. That's all
Thank
the
you.
time we have. Thank you both so much.
Thank you.
Thank you.
We've heard today about the Carney government's plans to expand the scope of the criminal law to capture more speech crimes. Hate is a terrible thing, but can hate actually be legislated out of the human heart? I'm skeptical, and I have concerns about the constitutionality of Carney's plan, but you be the judge. Thanks for watching, and remember, a freer Canada starts with you.